Okay. So on the last occasion, we went through the general principles. We got as far as the plea of justification, I believe. But we will take it from the top. General, we're going up to defense, general denial insufficient, section 1, general principles. General denial insufficient. The defendant must not plead a general denial of the allegations in the particulars of claim. He must take each allegation separately and either admit it or deny it, or say that he is unable to admit or deny, but requires the claimant to prove it. Where the defendant denies an allegation, he must state his reasons for doing so. And if he intends to put forward a different version of events that given by the claimant, he must state his own version. A different version of events from that given by the claimant, he must state his own version. The defendant must plead with sufficient precision and clarity so as to enable the claimant to know what he will be obliged to prove and what case he must prepare to meet, while also paying due regard to the requirement of proportionality in the manner in which he advances his case. Specific denials. In a defamation action, the defendant may simply contest the claim on the basis that the claimant will be unable to establish the essential requirements of the cause of action. The defendant will succeed if the claimant fails to prove that the words are defamatory, or if defamatory, that they were published by the defendant to a third party, or if published by the defendant, that they would be understood by reasonable people to refer to the claimant. Okay, so we're going to make a piece of this bold. All right. Okay, so we're going to bold from the defendant may simply, you seeing that up there? Go up a little bit. The very first line, the defendant may simply contest the claim on the basis that the claimant the defendant may simply contest the claim on the basis that the claimant will be unable to establish the essential requirements of the cause of action. And stop there, bold that piece, please. Right, perfect. Okay, the defendant will succeed if the claimant fails to prove that the words are defamatory, or if defamatory, that they were published by the defendant to a third party, or if published by the defendant, that they were understood by reasonable people to refer to the claimant. Okay, so we're going to bold a piece of this as well. You see the sentence beginning, the defendant will succeed if the claimant, you seeing that? All right, so take it from the claimant, that sentence, the claimant, we're going to bold this piece, the claimant fails to prove that the words, all right, and stop at words, bold up the words, and then continue, were published by the defendant to a third party. Were published by the defendant to a third party. Yeah, from there, right. Up to third party. Okay? Or if published by the defendant, that they would be understood by reasonable people to refer to the claimant. The defendant is entitled to put the claimant to proof of all the facts alleged in the particulars of claim. That sentence, the defendant is entitled to put the claimant to proof of all the facts alleged in the particulars of the claim. So that should be bolded. Yeah. Accordingly, where appropriate, the defendant should deny or not admit that he published the words complained of. Okay. The defendant should deny those four words, bold them, and then that he published the words complained of. The defend, right? Perfect, bold that, right. The defendant should not, however, deny or refuse to admit that he wrote or published the same falsely or maliciously as alleged. Those are in quotations, yeah. For this might be construed as an indirect plea of justification. All right, a defendant should no longer in any event be placed by a claimant in the position of having to plead such an averment. In parentheses, if the defendant proposes to contend that the words do not refer or for some reason are not capable of referring to the claimant, he should plead accordingly. All right, so we're going to bold piece of that as well. If the defendant proposes to contend that the words do not refer or for some reason are not capable of referring to the claimant, he should plead accordingly. That whole sentence. Further, if the defendant contends that the words do not bear the defamatory meaning alleged by the claimant or are incapable of bearing that or any other defamatory meaning, he should say so. All right, so in that sentence now, that sentence that begins further, you're going to bold, the defendant contends that the words do not bear the defamatory meaning alleged by the claimant. Right, just that piece. The defendant must state in his defense what he alleges the meaning of the words is, if it is relevant to some substantive defense he wishes to raise, such as justification, fair comment, qualified privilege, or to the quantification of damages, and it may be desirable for him to do so in any event to enable the claimant and the court to understand his case on meaning. Okay. All right, so that sentence with bold and piece. The defendant must state in his defense right? Bold that. The defendant must state in his defense the meaning, and then you leave the remaining words blank, and then you bold the meaning, right? The meaning of the words is. Hmm? No, 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 don't include the word. All right, word is about the defense. If it is relevant, some substantive defense. Okay, all right. And then bold the next few, which are some substantive defense, such as justification, fair comment, qualified privilege. Justification, fair comment from justification, or to the quantification of damages. All right, so you're stopping at privilege. Right. Qualified privilege is the last thing that's bolded. And then, or to the quantification of damages, and if it may be desirable for him to do so in any event, to enable the claimant and the court to understand his case on meaning. The defendant should consider with some care his response to the meanings pleaded by the claimant. While it is open to a defendant both to deny that the words bear a defamatory meaning and to advance a plea of justification, such an approach may be difficult to sustain forensically. Where words are capable of bearing the meaning attributed to them by the claimant, the right course may be to admit as much and to plead whatever substantive defenses are available to the defendant. Before serving any defense, the defendant should consider whether to make a general or qualified offer of amends under Section 2 of the Defamation Act 1996. S2, yeah. An offer to make amends cannot be made after service of the defense.
Where am I reading from, please?
Which was a reading from substantive defense.
Substantive defenses. either in addition to or alternatively to his denial of all or some of the claimant's pleaded case, the defendant may put forward one or more substantive defenses which defeat the claimant's claim. The defendant may plead as many different alternative defenses as he wishes, even though the allegations are inconsistent, although it may not always be prudent for him to do so. He must, however, arrange his defenses so as not to confuse the issues and embarrass the claimant. And that's it.
Okay. 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 Either in addition to or alternatively to his denial of all or some claimants, the defendant may put forward one or more substantive defenses which defeat the claimant's claim. Okay, all right, let's move on now to damages.
Ready?
Yes.
The defendant must respond specifically to any claim for damages. Where special damage is required to be alleged in support of a claim for words actionable only on proof of special damage, the defendant should, where appropriate, object that none is pleaded, or that the special damage pleaded is too remote, or that it is insufficient in point of law. Facts and matters relied on in mitigation of, or otherwise in relation to, the amount of damages should be expressly identified. It should be noted that a bare denial that the claimant suffered distress arising out of the publication is not sufficient if the defendant intends to raise a positive case of alternative cause of distress. If the defendant wishes to raise
hold on there, hold on. It should be noted that a bare denial arising out of defendant intends to raise. Okay, yeah, go ahead. Defendant.
If the defendant wishes to raise a positive case putting causation in issue, he must do so expressly and with full peculiarity in his defense.
Particularity.
Particularity.
All right. Let's go on to section 2, plea of justification.
You ready?
Yes.
When to plead this defense. If the defendant intends to justify, he must raise a plea of justification specifically in his defense.
Defense in that instance has an S?
C.
Okay. Go ahead.
Continue.
Yes, please.
A pleader should not put a plea of justification on the record lightly or without careful consideration. Before pleading justification, a defendant should, 1, believe that the words complained of, in parentheses, in some defamatory meaning they are reasonably capable of bearing, close parentheses, are true. 2, intend to support the defense at trial. And 3, have reasonable evidence to support the plea or reasonable grounds to suppose that sufficient evidence to prove the allegations will be available at trial.
All right, stop there for a minute. All right, go ahead.
Are we at it?
Yes.
It is often the case that the defendant is unable to compile all the necessary evidence to mount a plea of justification, and serve his defense within the prescribed time. In such cases, it is the usual course for the defendant to apply to extend the time for service of his defense.
All right, stop for a minute. All right, go ahead.
A reasonable extension of time will generally be granted where the defendant is able to give the adequate reasons for requiring it. Where the court refuses an extension of time, the defendant should serve whatever defense he can at that time and seek to amend his defense to introduce a plea of justification at the earliest possible opportunity after the necessary evidence has become available.
Mm-hmm.
The defendant should bear in mind that it is possible that a failure to establish a plea of justification at the trial will be permitted to be taken in aggravation of damages. However, a failure to plead justification is not to be taken as an admission of the falsity of the allegations made for the purposes of a claim or an injunction to restrain their repetition.
Mm-hmm.
This is another point, exact words in the particulars of claim must be justified.
Of the claim.
Of claim, no, of
Of
claim.
claim. Okay.
Particulars of claim, sorry. The defendant must justify the precise words set out in the particulars of claim. He is not entitled to set out his own version of the words and then plead that those words are true.
Stop. Stop. And then, all right, go ahead.
To do so would be, quote, like pleading to a statement of claim alleging that the defendant has said that the plaintiff stole a pair of boots, that what the defendant said was that the plaintiff's footman stole the boots, and that was true, close quote.
Mm-hmm.
If the words which the defendant published are materially different from those alleged in the particulars of claim, he should simply deny publication.
Hold on. Mm. Okay, go ahead.
If the claimant fails to prove that the words he alleges were in fact published, he fails to prove his case.
All right.
Continue.
Yes.
Justifying the words in their natural and ordinary meaning. Where a claimant complains that the words are defamatory of him in their natural and ordinary meaning, the defendant is entitled to justify those words in any meaning which those words are capable of conveying to a reasonable man. In all cases where a defendant alleges that the words complained of are true, he is required to specify the defamatory meaning or meanings he intends to justify. The meaning in which a defendant seeks to justify defamatory words must, however, be a defamatory meaning.
Stop. All right, go ahead.
If the claimant has selected certain words from a publication and pleaded that, in their natural and ordinary meaning, they are defamatory of him, the defendant is entitled to look at the whole of the publication in order to aver that, in their context, the words bear meaning different from that alleged by the claimant, and to plead that, in the meaning the word in, and to plead that in that meaning the words are true.
Keep going.
In giving particulars in support of his plea, the defendant is entitled to cull some or all of the facts and matters from parts of the publication of which the claimant has chosen not to complain, provided that he does not attempt to justify separate and distinct defamatory statements contained in the publication, which do not share a common sting with the defamatory allegations contained in the words complained of. The preferred and usual practice is to set out the meaning or meanings at the start of the plea of justification. When a properly drafted plea of justification is included in the defense, it is permissible to rely on any facts that are proved in order to support it to reduce the damages, even though those facts by themselves turn out to be insufficient to make good the defense as a whole. However, it is not permissible to plead under the guise of particulars of justification, alleged facts and matters with a view to leading evidence about such matters solely to support an argument that the claimant should receive a smaller sum by way of damages. To adopt this latter course is an abuse of the process of the court. The court will be careful to distinguish between a defendant genuinely seeking to justify a lesser and different defamatory meaning which the words are capable of bearing, and one who is impermissibly trying to obtain a partial justification of the whole sting of the libel pleaded by the claimant. It is also not permissible to lead a Lucas box meaning in the form of a hearsay statement. For example, to seek to justify a defamatory publication in the meaning that A said that B murdered C, where B is the claimant.
Mhm.
Partial justification. Where there is, in effect, a single broad defamation made by a single publication, the attack must be justified as a whole, and it cannot be justified by saying that the publication was partly true. However, where the claimant complains about a number of defamatory allegations contained in a publication, the defendant may justify some only, provided the charge or charges which he justifies can be divided from the rest and convey a distinct and separate imputation on the claimant. If the defendant takes this course, he must make the separation so that the court may see quite clearly which charges he justifies and which he does not.
All right, stop right there. All right, keep going.
If he leaves it doubtful, his defense may be struck out as embarrassing. Before pleading justification of any individual charge, the pleader is under a duty to satisfy himself that evidence is available to justify the plea. Where the defendant considers that he may wish to rely on S5 of the Defamation Act 1952 in respect of one or more distinct defamatory charges, he should expressly plead that section in his defense. Do I continue?
Keep going.
Justifying an innuendo meaning, where the claimant relies on a true legal innuendo. He sets out a separate cause of action.
Stop. It's untrue.
Yeah,
The
that's what they
end.
have.
All
The
right.
end.
Okay, if that's what they have.
Right, continue.
Mm-hmm.
It is submitted that the defendant wishing to meet the separate cause of action with a plea of justification must confine himself to the legal innuendo meaning contended for by the claimant.
Stop. All right, keep going.
The reason for this is that in such a case, the claimant's complaint is peculiarly tied to the extended meaning which he seeks to place on the words on the words, quote, created by a conjunction of the words with something outside them, close quote.
Mm-hmm.
The claimant's case depends on his being able to establish precisely this extended meaning, and the defendant who seeks to justify some other meaning will not meet the claimant's case.
Mm-hmm.
Pleading particulars of justification. While it used to be acceptable on very rare occasions where the defamatory words themselves contained very specific and detailed charges, for the defendant to allege generally that the words were true without giving any particulars, it is now necessary, in order to comply with the rules of pleading for the defendant, to give details of the matters on which he relies in support of his plea of justification.
You can pause. You can mute the mic. Eh? What you said? Yeah. No, that's all, man. Yeah, yeah.
Thus, where a general charge of misconduct is made and the defendant seeks to enter a plea of justification, he must plead the specific instances of misconduct with which he seeks to justify the charge with sufficient peculiarity as to enable the claimant to know precisely what are the facts to be tried. For example, where the claimant is accused of incompetence, administrative or financial mismanagement, and dereliction of duty, the defendant must give a clear indication of what he suggests the claimant did or did not do. Similarly, where the defendant says that the claimant's workmanship is shoddy, he must provide examples of specific work claimed to be shoddy.
All right, stop. Okay, keep going.
The defendant should, however, ensure that, in particularizing his plea of justification, he confines himself strictly to the issues necessary for a fair determination of the dispute between the parties and does not act oppressively.
Mm-hmm.
Where a serious allegation of dishonesty is made against the claimant, there is a particular obligation on the defendant to plead full details of that allegation, setting out what was alleged to have been known by whom.
All right, stop there for a minute. Okay. Mm-hmm.
Further, and this is quote and in small font,
Mhm.
There is a rule of general application in defamation, brackets, dubbed the repetition rule, close bracket, whereby a defendant who has repeated an allegation of a defamatory nature about the claimant can only succeed in justifying it by proving the truth of the underlying allegation, well, yeah, not merely the fact that the allegation has been made, close quotation, end of small font.
Mhm.
In the case of a defensive justification of reasonable suspicion, it is usually a requisite of such a defense that it should focus on some conduct of the claimant giving rise to reasonable suspicion. It is also necessary for the defendant to plead the primary facts and matters which, objectively judged, and that's in italics,
Mhm.
are said to have given rise to reasonable grounds of suspicion. In this regard, it is impermissible to plead as a primary fact the proposition that some person or persons announced, suspected, or believed the claimant to be guilty. It may be open to a defendant to adduce hearsay evidence to establish a primary fact, but that in no way undermines the rule that statements, in quotes, still less the beliefs, end quote, brackets, of any individual cannot themselves serve as primary facts. So just to correct, still less the beliefs, that's in brackets.
Mhm.
Further, it is not of any, sorry, it is not permitted to justify a reasonable ground for suspicion meaning with reference to post-publication events, since the issue falls to be judged as at the time of publication.
Mhm.
It is, however, permissible for a defendant to rely upon pre-publication events of which he was unaware at the time he published the material complained of. Where a defendant seeks to prove the truth of a relevant fact by way of justification, and the claimant makes an admission in respect of that fact, the court may, in a particular case, decline to allow the defendant to continue to maintain his allegation in the face of the admission, even where it does not match exactly the defendant's allegation.
Mhm. Yeah.
Miscellaneous considerations. Where the defendant wishes to rely on S13 of the Civil Evidence Act 1968, the defendant should plead the relevant conviction, notwithstanding that the rule relating to the pleading of conviction in reliance upon the other sections of that act does not expressly extend to pleading a criminal conviction in a defamation action in reliance upon S13.
All right. Section 3. Plea of fair comment. Defense must be specially pleaded. The defense of fair comment must always be specially pleaded. The defendant should not, however, enter a plea of fair comment unless he is satisfied that the facts which are relied upon in support of the plea are true and he has reasonable evidence to support them or reasonable grounds for supposing that sufficient evidence to prove them will be available at the trial, at which he intends to support the defense. Where a defendant alleges that the words complained of are fair comment on a matter of public interest, he must specify the defamatory meaning which he seeks to defend as fair comment. This rule derives from the somewhat uncertain requirement which existed prior to the introduction of the CPR. The defendant should specify, usually at the start of his pleading of the defense of fair comment, the comment in the words complained of, which he will contend falls within his defense. A comma afterward? No, there's no comma there. Yeah, there is a comma specified. So I'll read that over. The defendant should specify, comma, usually at the start of his pleading of the defense of fair comment, comma, the comment in the words complained of, comma, which he will contend falls within this defense. In advancing a plea of fair comment, the defendant is entitled to look at the whole of the publication, and he may cull facts on which he alleges the comment to be based from parts of the publication of which the claimant has not complained, provided those facts cannot be said to be separate and distinct defamatory statements. Okay, so we're bolding the sentence just after CPR. The defendant should specify, you see in that? All right, the defendant should specify, usually at the start of his pleading of the defense of fair comment, the comment in the words complained of which he will contend falls within his defense, just that sentence. All right, pleading fair comment. Moving on, next paragraph, pleading fair comment. If the pleader is in any doubt as to whether words which he seeks to defend by way of a plea of fair comment are indeed comment, as opposed to defamatory statements of fact, he should include a plea of justification in his defense. Okay, by contrast, if the words complained of are plainly comment, there may be advantages for a defendant in limiting himself to a defense of fair comment. Okay, pleading particulars. The defendant must give details of the matters on which he relies in support of the allegation that the words complained of are fair comment on a matter of public interest. He must give particulars of all the facts upon which the comment is legitimately based. That is, of the facts which go to the pith and substance of the matter. In quotation marks. All right. He must make the issue clear and unmistakable, stating that stating what are the facts which are alleged to be true and what expressions of opinion are the subject of fair comment. The defendant can and should give such particulars notwithstanding. Mhm. I'll start that sentence again. The defendant can and should give such particulars notwithstanding that they are defamatory and he has not raised a plea of justification. Where the defendant considers that he may wish to rely on Section 6 of the Defamation Act 1952 in respect of his plea of fair comment, he should expressly plead that section in his defense, pleading fair comment on privileged statements. Yeah, yeah, that space that was there, leave it. Okay, pleading fair comment on privileged statements, where defendant contends that his comment was based on a statement previously made on a privileged occasion. He need not aver the facts in the statement were true, but he must allege and prove that both the statement was made on a privileged occasion and that his report of it was fair and accurate. Both that the statement, yeah, pleading matter of public interest. The defendant should specify the matters which he alleges to be of public interest, where he contends that the matter is of public interest because the claimant invited criticism or comment. He should plead all facts and matters relied upon in support of such allegation. Miscellaneous considerations. It is not appropriate for the defendant to aver that the comment was expressed without malice and in good faith. Section 4, plea of privilege. Defense must be specially pleaded. Where a defendant alleges that the words complained of were published on a privileged occasion, he must specify the circumstances he relies on in support of that contention. Basis of privilege to be stated. Where he is required specifically to raise the defense of privilege, the defendant should allege and prove the facts and circumstances which he claims bring him within the protection of the privilege. Thus, where the defendant alleges that a privilege arises from corresponding interests and duties, it must appear that the subject matter of the communication complained of is one in which the defendant and the party to whom he made the communication had corresponding interests or duties. Mhm. Right. Where he is required specifically to raise the defense of privilege, the defendant should allege and prove the facts and circumstances which he claims bring him within the protection of the privilege. Yeah. Similarly, where the plea of privilege is founded on legitimate self-defense, the defendant must aver such facts as will enable the court to determine whether the statement complained of is sufficiently connected with and relevant to the attack or charges made by the claimant to bring it within the privilege. The plea of privilege should be directed at the actual publication and not at the various meanings or innuendos which the claimant claims to arise from the words of the publication. The publication. Yes. An averment that the words were true, an averment that the words were published bona fide and without malice is not essential to the validity of a plea of qualified privilege and should not be pleaded, as in such a case there is a presumption of bona fides on the part of the defendant. Averment. Where such continue where such an immaterial allegation is made, no particulars of it will be ordered. All right, pleading Reynolds qualified privilege, where defend. Mhm. No. Yes. Yes. Where a defendant, newspaper, or other publisher claims that its dissemination of defamatory material to the public is covered by this species of qualified privilege, elaborated by the House of Lords in Reynolds versus Times Newspapers Limited, it must demonstrate why the nature of the subject matter of the publication was such that it was in the public interest for it to be published. Yes. In fact, yeah, and we're going to bold that piece, right? It must demonstrate, we're bolding from, it must demonstrate why the nature of the subject matter of the publication was such that it was in the public interest for it to be published. Stop there, right? It is the publication as a whole that has to be assessed when considering the public interest, not merely the particular defamatory allegations of which the claimant complains. Yes. Hmm. The defendant must also set out the circumstances of the publication said to support publication in public interest, existing at the date of publication, such as the seriousness of the allegation, the extent to which it, yes, the extent to which it was a matter of public interest, the source, and the status of the information, the steps taken to verify the urgency of the matter, and the steps taken to obtain and print the claimant's side of the story. Yes. All right. All right. All right. That sentence bolded from the defendant must also set out up to the claimant side of the story. You ready? Sorry. Right. Nice. In an appropriate case, it may be necessary. Sorry. Or responsible journalism in all the circumstances must be demonstrated. In an appropriate case, it may be necessary or at least admissible for a defendant to plead and prove a subjective belief in the truth of its publication in order to establish a defense of Reynolds privilege. In such a case, the defendant should expressly identify the meaning it contends the individuals responsible for the publication understood it to bear, pleading privilege in relation to incidental publication. Where a defendant contends that the communication in question was protected in law because it was made incidentally to a privileged communication, he should expressly aver that the incidental publication was reasonable or necessary in order to bring the document to the notice of those to whom it was his duty or interest to communicate it. He should expressly aver. All right.
Section 5, other pleas. Offer of amends. A person wishing to rely by way of defense on the fact that he has made an offer of amends under Section 2 of the Defamation Act 1996 should do so expressly. He should specifically state that he is relying on the offer in accordance with Section 4(2) of the Defamation Act 1996 and that it has not been withdrawn by him or been accepted. He may wish to attach to his defense a copy of the offer which he has made. He need not, however, plead that he did not know nor have reason to believe that the statement complained of referring to the claimant referred to the claimant or was likely to be understood as referring to him and was both false and defamatory of the claimant, since these matters are presumed in the defendant's favor until the contrary is shown. Where did we stop, please? He need not, he need not, however, plead that he did not know nor have reason to believe that the statement complained of referred to the claimant or was likely to be understood as referring to him and was both false and defamatory of the claimant. We did that already. Since these matters are presumed in the defendant's favor until the contrary is shown. It should be borne in mind that the defendant who has made an offer of amends under Section 2 is not obliged to rely on it by way of defense. But if he does so, he may not rely on any other defense. I do need to stop this and have lunch. secondary publication, and innocent dissemination. A printer, distributor, seller, broadcaster, service provider, or other person seeking to rely on the statutory defense under Section 1 of the Defamation Act 1996 should plead 1. That he was not the author, editor, or publisher of the statement complained of; 2. That he took reasonable care in relation to its publication; and 3. That he did not know and had no reason to believe that what he did caused or contributed to the publication of a defamatory statement. The defendant should identify those facts and matters on which he will rely in support of the argument as to reasonable care. It will no longer be necessary or appropriate to rely on the common law defense of innocent dissemination, which is effectively superseded by the statutory defense.
Limitation Act. Where the defendant wishes to raise the statute of limitations, he should do so expressly in his defense. Other defenses making the claim not maintainable. Similarly, the defendant must plead specifically any other matters such as release, consent, accord and satisfaction, or res judicata, which he alleges makes the claimant's claim not maintainable. If the defendant wishes to raise a defense based on foreign law, he must expressly plead the relevant law in his defense. A defendant who seeks to rely on any provision of a right arising under the Human Rights Act 1998 or seeks a remedy available under that act must state that fact in his defense and set out various other prescribed matters. Okay, so let's see. Similarly, the defendant must plead specifically. All right, let us mitigation of damages. The well-established practice is for the defendant specifically to plead in his defense. The well-established practice is for the defendant specifically to plead in his defense particulars of any facts on which he relies in mitigation of or otherwise in relation to the amount of damages claimed. The plea must be clear and precise. Matters pleaded may include the fact that there has been an offer or publication of unilateral correction or apology, or they may relate to the circumstances under which the libel or slander was published. Example, that the claimant provoked the publication by previously attacking the defendant. A defendant may in certain circumstances rely on the failure of the claimant to take up an offer to respond to the material published or to be published. Okay. A defendant may also plead in mitigation of damages the claimant's general bad reputation. The defendant may at trial rely in mitigation of damages on any evidence properly before the court, including evidence which has been primarily directed to an unsuccessful plea of justification or fair comment. The defendant may at trial in mitigation of damages. The defendant may at trial rely in mitigation of damages on any evidence properly before the court, including evidence which has been primarily directed to an unsuccessful plea of justification or fair comment. It is increasingly the practice for a defendant to include in his defense an averment to the effect it is increasingly the practice for a defendant to include in his defense an averment to the effect that he will rely, if and insofar as it is necessary, on such evidence at trial in mitigation of damages. The defendant may also plead in mitigation of damages directly relevant background, context, material. Defendant may also plead in mitigation of directly relevant background, context. It is increasingly the practice for a defendant to include in his defense an argument to the effect that he will rely, if and insofar as it is necessary, on such evidence at trial in mitigation of damages. Defendant may also plead mitigation of damages directly relevant background, context, material. Where the defendant makes an offer to make amends, should the defendant wish, if the offer is accepted, to rely on at any subsequent hearing to assess the compensation due to the claimant on any background contextually, should serve on the claimant a statement of case setting out the facts and matters on which he intends to rely. A defendant may not rely in mitigation of damages on the fact that there have been other publications to the same or similar effect as the publication complained of, about which the claimant has not complained, whether the other publications were made by the defendant or not. Section 12 of the Defamation Action 1952, where a defendant proposes, in accordance with Section 12 of the Defamation Act 1952, to give evidence in mitigation of damages that the claimant has recovered damages or has brought actions for damages for libel or slander in respect of the publication of words to the same effect as the words on which the action is founded, or has received or agreed to receive compensation in respect of any such publication. He should plead the relevant events, giving particulars of the occasions on which he relies. Statement of truth. A defense must be verified by a statement of truth. Proceedings for contempt of court may be brought against a person if he make or causes to be made a false statement in a document verified by a statement of truth without an honest belief in its truth. Making a counterclaim. In an action for defamation, statement of truth. Statement of truth. A defense must be verified by a statement of truth. Proceedings for contempt of court may be brought against a person if he makes if he make or causes to be made a false statement in a document verified by a statement of truth without an honest belief in its truth. Making a counterclaim. In an action for defamation, a defendant who alleges that he has been libeled or slandered by the claimant, or who has any other claim against the claimant, may, instead of bringing a separate action, make a counterclaim, whether it involves a claim for damages or not, by adding the counterclaim to his defense, and the court is entitled to pronounce a final judgment in the same action on claim and counterclaim. But if the claimant persuades the court that the counterclaim should be dismissed or dealt with separately from the main claim, the court may at any time rule accordingly. The defendant may raise a counterclaim against the claimant along with some person not a party to the action. A counterclaim is governed by the same rules of pleading as particulars of claim. The defendant should state the facts in numbered paragraphs under the heading Part 20 Claim, so as to distinguish them from the facts alleged by way of defense. If any of the facts on which the counterclaim is founded have already been pleaded in defense, they need not be pleaded again in the counterclaim but may be incorporated by reference. Contribution. Section 9. Contribution. Tortfeasors liable for the same damage. The defendant may, if he wishes, claim a contribution from any other person who is liable in respect of the same damage, whether jointly or otherwise. The amount of the contribution recoverable from any person under the Act shall be such as may be found by the court to be just and equitable, having regard to the responsibility of that person for the damage, and the court is empowered to exempt any person from liability to make contribution or to direct the contributions to be recovered from any person shall amount to a complete indemnity. Indemnities. Under Section 11 of the Defamation Act 1952, an agreement for indemnifying any person against civil liability for libel in respect of the publication of any matter shall not be lawful unless at the time of the publication that person knows that the matter is defamatory and does not reasonably believe there is a good defense to any action brought upon it. Such a term is common in agreements for broadcasting or the publication of books. And the claim under it, if the term is lawful, is for indemnity and not for contribution under the 1978 Act. However, unless protected by Section 11 of the Defamation Act 1952, an express promise by A to indemnify B, if he will publish a libel, is void, and it seems unlikely that it would be allowed to found a claim for contribution under the 1978 Act. Procedure and pleading. A claim by a defendant against any person, whether or not already a party for contribution or indemnity, is included within the definition of Point 20 claim under the CPR. A defendant who has filed an acknowledgement of service or defense may make a Point 20 claim for contribution or indemnity against another defendant by filing a notice containing a statement of the nature and grounds of his claim and serving it on the other defendant. A claim for contribution or indemnity against a person who is not already a party is made when the court issues a Point 20 claim form, which must be in the prescribed form. Particulars of the claim must be contained in or served with the Point 20 claim form. A defendant may make such a claim without the court's permission if the Point 20 claim is issued before or at the time as he files his defense. At any other time, the court's permission is required. An application for permission may be made without notice, where the court gives permission to make a Point 20 claim. It will at the same time give direction to the service of the Point 20 claim. Section 10. Misuse of private information. Generally, as in claims for defamation, the defendant must take each allegation and the particulars of claim separately and either admit it or deny it, or say that he is unable to admit or deny it, but requires the claimant to prove it. Where the defendant denies an allegation, he must state his reasons for doing so, and if he intends to put forward a different version of events from that given by the claimant, he must state his own version. The defendant must plead with sufficient precision and clarity so as to enable the claimant to know that he will be obliged to prove, what he will be obliged to prove and what case he must prepare to meet. So, for instance, if the defendant denies that the relevant information is private to the claimant, or that the claimant had a reasonable expectation that the information would be kept private by the defendant. He should plead as much. Similarly, if the defendant wishes to deny an allegation in the particulars of claim that he had a pre-existing relationship of trust and confidence with the claimant, or that he was, for some other alleged reason, on notice that the information was private to the claimant. Further, the defendant may put forward one or more substantive defenses in answer to the claimant's claim. Example, that the claimant gave his consent to his use of the relevant information, that the information was in the public domain, or that his publication or other use of the information was justified in the public interest or with reference to the defendant's right to freedom of expression. The defendant should respond specifically in his defense to any fact and matters pleaded in the particulars of claim in support of a claim for general compensatory or aggravated damages, and should also set out any facts and matters upon which he wishes to rely in mitigation of damages. Amendment, Section 11, Amendment of Defense and Counterclaim. After defendant has served his defense, he may only amend it with the written consent of all the parties or with the permission of the court. If the amendment involves the removal, addition, or substitution of a party, the permission of the court is required. Where the defendant seeks permission to amend his defense, he should apply under CPR Point 23 by application notice. A copy of the proposed amended statement of case should be filed with the application notice. Granting of permission in discretion of court. Permission to amend will normally be given freely if the overriding objective requires it and there is no element of surprise or prejudice which cannot be compensated by an appropriate order, as the cost or otherwise. The court has shown itself less willing, however, to grant a defendant permission to amend his defense where the application is made late in the day, either at or close to the trial. In particular, when a defendant seeks to introduce or expand the plea of justification at a late stage, his conduct will be closely inquired into, and the court will expect him to have shown due diligence in making his inquiries and investigations. A late application to add a defense of Reynolds qualified privilege will also be closely scrutinized by the court. Okay. All right. It has been held that where delay has been due to the defendant's own default in some respect, that circumstance should be taken into consideration by the judge as part of the matters to be weighed in deciding whether or not to allow an amendment. The mere fact that delay may be capable of being compensated in money is not conclusive of the question whether the amendment should or should not be permitted. In particular, although there is no rule that allegations of fraud must be pleaded at the outset and cannot be added by amendment, the court must be clearly satisfied that the opposing party is not prejudiced and that any inconvenience can be compensated before it allows a late amendment involving a serious allegation such as fraud or criminality for the first time. A belated application to amend should not, however, be refused on the ground that the proposed amendment would substantially increase the cost of the action, which the claimant, if successful, would be unlikely to recover unless there is also evidence to suggest that the amendments are shadowy or not bona fide. The court will be reluctant to refuse permission to add or extend the plea of justification solely for reasons of delay because it is not in the public interest that defamation claimants should recover damages and thereby achieve a public vindication of reputation which is not deserved. However, this consideration should not be regarded as a trump card, and it is always necessary to have regard to the overriding objective of the CPR and the consequences of a late amendment in terms of delay, cost, and stress for the claimant. The court, by contrast, will not hesitate at any stage to rule out, as a matter of case management, proposed particulars of justification, which are only of peripheral relevance to the central case in support of which they are sought to be advanced. The matter fundamentally is for the discretion of the court in all circumstances, and where it allows an amendment, it will usually do so on terms and subject, of course, to any adjournment which may be granted to allow the claimant an opportunity of meeting the amended defense. Conversely, when application to amend is refused, the defendant may, in an appropriate case, be given liberty to apply for permission to make a different, properly framed amendment. Although it is not required by the rules, a defendant making a late application to amend ought to put in a witness statement explaining the lateness. Where a defendant applied to amend his defense by raising a plea of privilege after the evidence was concluded and the jury had retired, it was held that the judge had rightly refused to allow such amendment. Where the defendants applied to amend their defense to raise a plea of justification following a trial of qualified privilege determined in favor of the claimant, the judge dismissed the application because the factors in favor of permitting the amendment were outweighed by factors against allowing it. In particular, the fact that the pleaded case was on its face insufficiently strong to warrant permission being granted to advance it at such a late stage. Default in service of defense. Generally, if the defendant fails to serve his defense within the proper time, the claimant may obtain judgment in default. The defendant and the claimant may agree that the prescribed period for filing a defense shall be extended by up to 28 days. Where the defendant requires longer than 28 days for service of the defense, the defendant must apply to the court for an order extending time, even where the extension is agreed between the parties. Even after time for service of the defense has expired, the defendant can still serve a defense at any time before judgment in default is signed, and such defense cannot be treated as a nullity. Judgment for an amount to be decided by the court. Where the claimant's claim is for damages only, the claimant may obtain a default judgment by filing a request in the relevant practice form. The default judgment obtained in such circumstances will be for an amount to be decided by the court and costs. On the entry of the judgment, the court will list the disposal of hearing. At the disposal hearing, the court will give directions or decide the amount payable. Where the claimant applies for default judgment against one of two or more defendants, the court may enter a default judgment on the claim against the defendant, and the claimant may continue the proceedings against the other defendants, provided that claim can be dealt with separately from the claim against the other defendants. If it cannot be dealt with separately, the court will not enter a default judgment, and it must deal with the claimant's application at the same time as it disposes of the claim against the other defendants. When an injunction is claimed, if the claimant's claim consists of or includes a claim for an injunction, the claimant must make an application in accordance with CPR Point 23 if he wishes to obtain a default judgment, unless he abandons that claim in its request for judgment. On an application for default judgment shall be such judgment as it appears to the court that the claimant is entitled to on his statement of case. Application for further information. Where the defendant has not provided adequate particulars of his case in his defense, the claimant should apply by letter for the particulars before making formal application to the court. Where the application is made to the court, the application notice may, where appropriate, ask that in default of provision of clarification and further information, that the allegation should be struck out of the defense. The advantage of obtaining particulars is that the claimant will know precisely what case the defendant is going to make at the trial and be able to prepare accordingly. Moreover, the issues will be defined by the matters Moreover, the issues will be defined by the matters specified in the particulars, and the defendant may not be permitted a trial without amendment to go into matters not fairly included within them. Demand must not be disproportionate. The court will be careful to see that the demand for particulars is not disproportionate or otherwise oppressive. Example, that the claimant is not covertly endeavoring to get something in which he is not to which he is not entitled, namely the disclosure of the evidence in the defendant's possession. The rule is that a party is entitled to an order for further particulars only for the purpose of ascertaining the nature of his opponent's case that he has to meet, and not for the purpose of obtaining advance notice of the evidence by which his opponent proposes to prove it. Where the claimant's application for particulars of justification is otherwise proper, it is no answer that in giving such particulars, the defendant may be compelled to disclose the names of persons he intends to call as witnesses. Okay, this brings us to the end of part 1. We will stop here and we will resume later on. So thank you for viewing. Enjoy the rest of your day.